Look at that pathetic old man, shuffling into the courtroom like he's lost, probably another homeless guy fighting a trespassing charge. A young law clerk whispered to his colleague, watching the elderly man slowly make his way through the imposing oak doors of Courtroom 7. The old man, Raymond Mercer, 72, didn't look up, his focus solely on finding an empty seat in the back row. He was just another face in the system, a fixture easily dismissed. But later, after a thoughtless comment led to his humiliation, and Judge Eleanor Harmon investigated his background, a different question echoed through the halls of justice. Why didn't you tell them who you really are, sir? Before we jump back in, tell us where you're tuning in from. And if this story touches you, make sure you're subscribed, because tomorrow I've saved something extra special for you. Raymond Mercer found a quiet dignity in the routines of his modest life. For the past 6 years, since his wife Margaret passed away and his retirement pension stretched increasingly thin against rising costs, he'd taken to representing himself in small claims court. Not as a plaintiff, but as an advocate for elderly neighbors in his community who couldn't navigate the complex legal system alone. He was a precise man. His handwritten briefs were always meticulously organized, his arguments trimmed with careful consideration, his demeanor respectful but firm. He kept to himself in the courthouse, exchanged polite but brief nods with the clerks and bailiffs he encountered regularly, and rarely spoke, unless addressed directly. He wore simple, clean clothes, somewhat dated suits that hung loosely on his increasingly thin frame, a carefully knotted tie that had seen better decades, and worn leather shoes polished to a respectable shine. His one indulgence was an old pocket watch that he consulted frequently, ensuring he never wasted the court's time. The young legal professionals, fresh from law school and brimming with ambition, barely registered him beyond a passing glance. To them, he was just another fixture in the courthouse landscape, the old do-gooder, a bit eccentric perhaps, harmless, easily overlooked. Some were kind, offering assistance with heavy documents or directions to relocated courtrooms. Others were indifferent. A few, caught up in their own professional arrogance, occasionally made quiet jokes at his expense, assuming his lack of formal legal credentials meant a simple mind or a life devoid of significant achievement. Raymond heard them sometimes, but he let it slide. He wasn't there for their approval. He was there for justice, for order, for the quiet sense of purpose that advocating for the vulnerable provided, a purpose that felt familiar, grounding even, in its humility. Few, if any, in that sprawling county courthouse knew that the hands now clutching handwritten legal notes had once signed opinions that shaped constitutional law, had gripped the gavel in federal proceedings, had shaken the hands of Supreme Court justices and presidents. Judge Raymond Mercer, retired, former Chief Judge of the Federal District Court, recipient of the Presidential Medal of Freedom, the Distinguished Jurist Award, and numerous other commendations, preferred the anonymity. The titles felt like they belonged to a different man, a younger man from a different lifetime. Here he was, just Raymond, helping those who couldn't help themselves navigate a system he understood intimately. "I don't know why they even let these amateur paralegals in here," whispered Daniel Harper, a junior associate at Brookfield and Stern, to his colleague. "That old man probably doesn't even understand the rules of evidence." His colleague, Melissa Chen, glanced uncomfortably at Raymond sitting quietly in the back row, reviewing his notes. "Maybe he's just trying to help people who can't afford real representation," she suggested. "Then they should go to legal aid, not waste the courts in time with some retiree playing lawyer." Daniel scoffed, loud enough for several people nearby to hear. "Look at him with his handwritten notes. Has he not heard of computers? Probably fought in World War II. Raymond didn't look up, but his shoulders stiffened slightly, the only indication he'd heard the dismissive comments. Today was important, He was representing Mrs. Abernathy, an 85-year-old widow being sued by a predatory contractor who had done shoddy repairs on her roof and was demanding payment in full. Raymond had spent weeks gathering evidence, photographing the defective work, and finding building code violations. The courtroom was moderately busy that Wednesday morning, filled with the usual mix of attorneys, plaintiffs, defendants, and court personnel. Judge Eleanor Harmon, newly appointed to the district court, presided efficiently through the morning docket. At 11:35, the clerk called Westbrook Construction versus Abernathy. Raymond helped Mrs. Abernathy to her feet, a tiny woman with a spine curved by osteoporosis but eyes sharp with determination. As they made their way to the front, Daniel Harper's voice carried again, "Great, now we all have to wait while Grandpa figures out which way is up on his legal pad." A few chuckles rippled through the gallery. Judge Harmon's eyes narrowed slightly, but she maintained her professional demeanor. "Good morning, Your Honor," Raymond began, his voice quiet but surprisingly clear and articulate. "Raymond Mercer, appearing as advocate for Mrs. Abernathy." "And you are an attorney, Mr. Mercer?" Judge Harmon asked, scanning her paperwork. "No, Your Honor. Mrs. Abernathy has authorized me to speak on her behalf as she has difficulty hearing and standing for extended periods. I'm appearing under the court's discretionary allowance for non-attorney representation in small claims matters." "Very well," Judge Harmon nodded. "Though I must advise Mrs. Abernathy that having non-legal representation may disadvantage her case." "We understand, Your Honor," Raymond replied with a slight bow of his head. The plaintiff's attorney, a slick-looking man representing Westbrook Construction, stepped forward. "Your Honor, if I may, we question whether Mr. Mercer has the competency to represent anyone in these proceedings. We believe this is simply a delay tactic. Preparing and narrating this story took us a lot of time, so if you are enjoying it, subscribe to our channel. It means a lot to us. Now back to the story." Raymond remained calm, his posture straight despite his years. "I'm prepared to proceed immediately, Your Honor. No delays requested." Judge Harmon studied Raymond for a moment, then nodded. "Proceed with opening statements." What followed surprised everyone except Mrs. Abernathy. Raymond Mercer presented a methodical, crystal-clear case demonstrating the construction company's negligence, complete with photographs, expert statements from 2 retired contractors he'd befriended, and relevant citations to state construction code. His presentation was concise, logical, and compelling. The plaintiff's attorney grew increasingly flustered, objecting frequently on procedural grounds. Each time, Raymond calmly referenced the relevant rule of procedure that permitted his evidence, or line of questioning. During a particularly heated exchange, the plaintiff's attorney exclaimed, "Your Honor, this is absurd. We're being opposed by someone who probably doesn't even know what stare decisis means." A small, knowing smile flickered across Raymond's weathered face before disappearing. "If counsel is concerned about binding precedent, I'm happy to provide." The court, with citations to Thompson versus Hendricks Construction and Morris Building Supply versus Johnston, both directly relevant to contractor liability in this jurisdiction. A bemused expression crossed Judge Harmon's face as she watched Raymond effortlessly navigate legal waters that even some attorneys found challenging. Something about his demeanor, his precision, and his command of legal principles struck her as incongruous with his appearance as a simple retiree. As the hearing continued, the atmosphere in the courtroom subtly shifted. The snickers and whispers faded. Even Daniel Harper watched with grudging curiosity as Raymond methodically dismantled the construction company's case. When both sides had presented, Judge Harmon rendered her decision in favor of Mrs. Abernathy, ordering the construction company to refund all payments and pay for repairs by a licensed contractor. "Thank you, Your Honor," Raymond said simply, helping Mrs. Abernathy gather her things As they turned to leave, Mrs. Abernathy's shaking hand knocked Raymond's worn leather briefcase to the floor, spilling its contents. Raymond knelt slowly to collect his papers, his joints protesting the movement. A small, blue velvet box tumbled out, opening upon impact to reveal a gleaming medal on a blue and white ribbon. Judge Harmon's eyes widened in recognition. "Mr. Mercer, is that a Presidential Medal of Freedom?" The courtroom fell silent. Raymond quickly gathered the medal and returned it to his briefcase. "It is, Your Honor, a keepsake from another time." "May I see it?" Judge Harmon asked, her tone more personal than judicial. Raymond hesitated, then approached the bench. He opened the box and presented the medal, one of the nation's highest civilian honors. Judge Harmon examined it with reverence, noting the inscription. Her expression transformed from curiosity to astonishment. "This was awarded to Chief Judge Raymond Mercer of the Federal District Court." She looked up sharply. "That's you?" Raymond nodded once, his eyes downcast. "Yes, Your Honor, many years ago." Daniel Harper and his colleagues exchanged shocked glances. The bailiff, a former military man, stood straighter in unconscious respect. "But why are you here representing Mrs. Abernathy in small claims court?" Judge Harmon asked, genuine confusion in her voice. Raymond's answer was simple: "Because she needed help, Your Honor, and I know my way around a courtroom." The incident that shattered Raymond's quiet anonymity began, as such things often do, with casual cruelty amplified by technology. Daniel Harper, still smarting from watching his colleague lose to what he thought was a doddering old amateur, captured a video of Raymond slowly making his way down the courthouse steps later that day. He added a condescending voiceover, mocking Raymond's careful gait and formal manner, captioning it, "Grandpa's Law School, Confusion and Prune Juice 101. Fake attorney, Jack Court Jester." He posted it to a popular unofficial legal community social media group. The post quickly gained traction, accumulating likes, laughing emojis, and a string of similarly thoughtless comments from other junior legal professionals. "Dude looks like he argued before the Lincoln assassination," one wrote. "Bet he represents clients for payment in Werther's originals," added another. No one defended Raymond. No one questioned the casual disrespect. No one recognized one of the most influential federal judges of the late 20th century, now retired and deliberately faded from public view. The post eventually came to the attention of the County Bar Association's Ethics Committee, then to the court administration, who, concerned about the image portrayed and potential violations of courtroom recording policies, reacted with bureaucratic swiftness. A memo was issued. Non-attorney advocates in the small claims division would now need to register with the court administrator and receive approval before being permitted to represent others, with preference given to formal legal aid organizations. It was a procedural excuse, a way to quietly remove the perceived problem without addressing the young attorney's behavior directly. Raymond, when informed by a flustered court clerk that he would need to apply for formal approval before representing any more community members, simply nodded. He understood subtext. He'd been effectively dismissed. He gathered his few reference books from the small desk he occasionally used in the courthouse law library, packed his worn briefcase, and left the county courthouse without a word of protest. The quiet assurance with which he had helped dozens of elderly neighbors replaced by an uncomfortable silence. He didn't mention the 30 years he'd served on the federal bench, the landmark decisions he'd written that were still taught in law schools, or the fact that the very courthouse they stood in contained a wing named after him, though the signage was modest and easily overlooked. He didn't reference the clerkships he'd provided to now prominent jurists, including 2 who sat on the Supreme Court. He simply accepted the new procedure with the same quiet dignity that characterized his entire life. The absence of the old advocate, as he'd come to be known, was noted peripherally at first. The small claims docket moved more quickly, but more elderly and low-income litigants lost their cases by default or through inadequate self-representation. Legal aid, perpetually understaffed and underfunded, couldn't absorb the sudden increase in demand. Daniel Harper and his cohort briefly congratulated themselves on solving the amateur hour problem and moved on to other amusements, climbing, and their respective law firm ladders. But Judge Eleanor Harmon, troubled by her brief encounter with Raymond Mercer and the Presidential Medal, began making inquiries. Something about the disconnect between the humble advocate and the prestigious award had captured her attention. When a senior clerk mentioned in passing that the Small Claims Division was seeing a spike in default judgments against elderly defendants, she made the connection and decided to investigate further. A quick database search confirmed what she had begun to suspect. Raymond Mercer wasn't just any retired judge. He had been Chief Judge Raymond Mercer of the Federal District Court for the Eastern Circuit, a judicial giant whose opinions on civil rights, access to justice, and procedural fairness had shaped American jurisprudence for decades. The more Judge Harmon read, the more her admiration grew and the more her discomfort deepened. She, a district court judge, had unknowingly played a part in sidelining a legal legend who had been quietly serving the most vulnerable members of the community. A man whose jurisprudential shoes she was not worthy to tie had stood humbly in her courtroom, asking nothing for himself, seeking only to help others navigate a system that often crushed those without resources or knowledge. She felt a knot of shame and anger tighten in her gut. She immediately summoned the court administrator and the head of the County Bar Association. "Find him," Harmon ordered, her voice tight, "and get me the name of every attorney who commented on that damned social media post. They have a lesson to learn." It took Judge Harmon's staff less than a day to locate Raymond Mercer living in his modest two-bedroom bungalow in the Oak Ridge neighborhood. The house was well maintained but simple, with a small garden of native plants that required minimal watering, a practical choice reflecting the owner's pragmatic nature. Judge Harmon drove there herself after court hours, still in her professional attire but without her judicial robe, a gesture of respect and humility. She found Raymond on his front porch, reading glasses perched on his nose, reviewing what appeared to be legal documents. Still helping others, she realized, even after being pushed away. When she approached, he rose with that same quiet dignity she'd observed in her courtroom. "Judge Harmon," he acknowledged with a slight nod, neither surprised nor perturbed by her presence. "Would you care for some tea? I was about to make a pot." "That would be lovely, Mr. Mercer. Or should I say, Judge Mercer?" A faint smile crossed his weathered face. "Raymond will do just fine. Titles fade, character remains." Inside, his home revealed a life of substance without ostentation. Bookshelves lined with legal texts and literature. Photographs of Raymond with Supreme Court justices and presidents receiving awards, and in quieter moments with what appeared to be his family. One framed photo showed him in his judicial robes, standing beside a much younger Eleanor Harmon, at what looked like a law school graduation. "University of Virginia, 2004, Raymond commented, noticing her gaze. "You were graduating editor of the Law Review. I was the commencement speaker." Judge Harmon's cheeks flushed with embarrassment. I don't remember. I'm so sorry." "No reason you should," Raymond replied kindly, pouring steaming tea into simple ceramic mugs. "There were hundreds of graduates, and I was just another old judge giving another forgettable speech about justice and integrity." His eyes twinkled. "Though it seems you absorbed the message regardless." They settled in his small living room, surrounded by the gentle ticking of an antique clock and the subtle scent of old books. Judge Harmon found herself uncharacteristically nervous, like a first-year law student called on unexpectedly in class. "Judge Mercer, Raymond, I've come to apologize, both personally and on behalf of the court. The way you were treated was inexcusable. I had no idea who you were." Raymond raised his hand gently. "And that's precisely as I wanted it. I didn't go to the courthouse seeking recognition or deference." "But why?" Judge Harmon couldn't contain her bewilderment. "You're Raymond Mercer. Your decisions on procedural due process are still cited almost weekly. The Mercer test for evaluating access to justice is foundational. You could have had your pick of prestigious positions after retirement: law school dean, distinguished, scholar, high-paid arbitrator. Instead, you're writing briefs for elderly neighbors and getting mocked by arrogant young attorneys who aren't fit to carry your legal pad." Raymond sipped his tea thoughtfully before responding. "When I retired, Eleanor, may I call you Eleanor? I found myself surrounded by accolades, but increasingly distant from the reason I became a lawyer in the first place. My father was a janitor who couldn't afford legal help when our landlord unlawfully evicted us. A local attorney helped us pro bono. That act of kindness changed the trajectory of my life." He set down his mug and leaned forward slightly. "After Margaret passed, I realized I'd spent decades interpreting law from on high, but had drifted from experiencing how it affects ordinary people. The Presidential Medal is a great honor, but it doesn't keep an elderly widow from being exploited by unscrupulous contractors." Judge Harmon felt a profound respect washing over her as Raymond continued. "There's a particular type of justice that happens in small claims court, immediate, tangible, life-changing for those involved. Mrs. Abernathy might have lost her home if that judgment had gone the other way. That matters more to me now than adding another line to my obituary." "But the disrespect you endured," Judge Harmon began. Raymond waved it away. "Young lawyers, they learn, sometimes the hard way. I've mentored hundreds over my career. Some start arrogant, but most find humility eventually, usually after life teaches them a few necessary lessons." "They will," Judge Harmon assured him, a plan already forming in her mind. "But first, we need to make this right. Would you do us the honor of returning to the courthouse, not as an advocate, but as our distinguished guest? There are some people who need to meet the man they so casually dismissed." Raymond studied her face for a long moment. "What exactly did you have in mind, Judge Harmon?" "A correction of the record, a lesson in respect and judicial history, and perhaps," she added with a smile that contained a hint of righteous mischief, "a reminder that true justice sometimes requires looking beyond appearances." Raymond considered this, then nodded once. "Very well, but on one condition." "Name it." "The new procedural barriers for non-attorney advocates must be reconsidered, not just for me, I'm only one person, but for all qualified individuals willing to help those who cannot afford representation. Access to justice shouldn't depend solely on one's bank account." "I'll personally see to it," Judge Harmon promised. As she rose to leave, her eye caught a framed quotation on Raymond's wall, yellowed with age. It read, "The true measure of justice is not found in landmark decisions, but in how the legal system treats its most vulnerable participants." The attribution simply read, "RM, Commencement Address 2004, her own graduation." Words she had heard but forgotten, spoken by the man standing before her who had lived those words every day since. The following Thursday morning, an unusual notice appeared on the county courthouse docket. A special educational session was scheduled in the main ceremonial courtroom, attendance mandatory for all attorneys who had been involved in cases in the small claims division over the past 6 months, as well as all court staff and judges. The session was titled simply "Perspectives on Justice," a distinguished lecture. Daniel Harper arrived late, irritated at having his billable hours interrupted for what he assumed would be another dull presentation on procedural updates. He slid into a seat in the back row, scrolling through emails on his phone, barely registering the unusual atmosphere in the packed courtroom. Had he been more observant, he might have noticed the presence of several state Supreme Court justices, the Attorney General and the Dean of the State Law School, all seated in the front row. He might have registered the hushed, anticipatory tone of the gathered crowd, so unlike the usual administrative gatherings. He might have perceived the subtle undercurrent of tension among the younger attorneys who, like him, had participated in mocking the old advocate online. At precisely 10 a.m., Judge Eleanor Harmon entered, but did not take her usual seat on the bench. Instead, she stood at the podium positioned before it. Distinguished colleagues, members of the bar, court, personnel and honored guests, she began, her voice carrying clearly through the ceremonial courtroom. We are gathered today for what may be the most important educational session in this courthouse's history. Daniel finally looked up from his phone, noticing for the first time the unusually prestigious audience. His law firm's managing partner was present, seated beside the county's chief prosecutor. What was this about? Recently, Judge Harmon continued, an incident occurred that has caused us to reflect deeply on the core values of our legal community. An incident involving disrespect, casual cruelty, and profound misjudgment. She gestured to a large screen where, to Daniel's horror, his social media post about Raymond appeared, along with screenshots of the mocking comments that followed, each with the commenter's name highlighted. Daniel felt blood drain from his face as he saw his own name prominently displayed, his managing partner turning to locate him with a thunderous expression. This post, Judge Harmon continued, her voice taking on an edge, and these comments represent a fundamental failure of the values we as legal professionals are sworn to uphold. They mock an elderly advocate who was volunteering his time to help vulnerable members of our community access justice. They display a breathtaking arrogance and a disturbing lack of basic human decency. Murmurs rippled through the courtroom. Daniel wanted to sink through the floor. Several other young attorneys looked equally mortified as their contributions to the mockery were displayed publicly. But there is a deeper failure here, Judge Harmon said, her voice softening slightly. A failure of recognition, a failure to see beyond appearances, a failure to honor the giants upon whose shoulders we all stand. She turned toward a side door. It is my profound honor to introduce our distinguished lecturer today, a jurist whose opinions have shaped American law for decades, a mentor who has trained generations of legal professionals, a humble servant of justice who even in retirement continues to embody the highest ideals of our profession. Ladies and gentlemen, please rise for the Honorable Raymond Mercer, former Chief Judge of the Federal District Court for the Eastern Circuit, recipient of the Presidential Medal of Freedom, and author of over 300 landmark opinions cited by the Supreme Court. The side door opened, and Raymond Mercer entered, but not as the humble advocate in dated suits that they had come to dismiss. Today he wore his formal judicial robes, the distinctive black with blue velvet panels marking his federal judicial status. He moved with quiet authority to the podium as the entire assembly, including state Supreme Court justices, rose in respect. Daniel Harper felt physically ill as recognition dawned. The old amateur he had mocked so mercilessly was one of the most revered federal judges in recent history, a constitutional scholar whose opinions he had studied in law school, a legal giant whose career was legendary. As Raymond reached the podium, Judge Harmon moved aside with a deep bow of respect. The elderly jurist surveyed the room slowly, his gaze eventually finding Daniel Harper in the back row. There was no anger in that gaze, only a profound sadness that cut deeper than rage ever could. "Thank you, Judge Harmon, for that overly generous introduction," Raymond began, his voice stronger and more resonant than Daniel remembered. "I come before you today not to chastise or to scold, though there is certainly cause for both. He removed his reading glasses, polishing them methodically with a handkerchief, the same deliberate movement Daniel had mocked in his video. Instead, I wish to speak about perspective, about the dangers of judgment based on superficial observation, about the ease with which we can forget that every person who enters these halls of justice carries with them a lifetime of experiences that we cannot begin to fathom from mere appearance. For the next 45 minutes, Raymond Mercer delivered what many would later describe as the most powerful lecture on legal ethics they had ever witnessed. He spoke without notes, drawing on 6 decades of legal experience. He shared stories of his early career, of landmark cases he had decided, of the weighty responsibility of interpreting constitutional principles, but he also spoke of Mrs. Abernathy and dozens like her, ordinary citizens navigating a complex legal system that often seemed designed to exclude them. He spoke of the court janitor who noticed when an elderly defendant seemed confused and quietly guided them to the correct courtroom. He spoke of the court reporter who stayed late, without extra pay, to ensure a transcript was ready for an appeal deadline. "Justice," Raymond said, his voice resonating through the silent courtroom, "is not merely found in grand pronouncements from marble buildings. It lives or dies in the small interactions, the daily kindnesses or cruelties, the moments when we choose to see or ignore the humanity of those before us." As he spoke, many in the audience found themselves moved to tears. Daniel Harper sat rigid, each word falling like a hammer on his conscience. His managing partner's earlier anger seemed to have transformed into deep disappointment, somehow far worse. "I do not stand before you seeking apologies or retribution," Raymond continued, approaching his conclusion. "I have lived long enough to know that humiliation rarely leads to genuine growth. Instead, I ask each of you, especially the young attorneys, who may one day sit where I have sat, to consider this. How do you wish to be remembered for the cases you won, the money you earned, the clever mockery you shared online?" He paused, letting the question hang in the air. "Or would you rather be remembered as someone who made the law more accessible, more humane, more just? Someone who saw dignity in every person who entered these doors seeking justice, regardless of their appearance, education, or station in life?" Raymond looked directly at Daniel again. "I would suggest to you that the latter path, though perhaps less immediately gratifying to the ego, leads to a far more rewarding life and a far more meaningful legacy." With that, he closed his leather portfolio and stepped back from the podium. For several seconds, absolute silence filled the ceremonial courtroom. Then, beginning with the Chief Justice of the State Supreme Court, applause erupted. It built like a wave until everyone present, judges, attorneys, staff, even the chastened young lawyers who had participated in the mockery, was on their feet in a standing ovation. Everyone except Daniel Harper, who remained seated, his face ashen, the full weight of his actions finally crashing down upon him. As the applause finally subsided, Judge Harmon returned to the podium. "Thank you, Judge Mercer, for that profound and moving address. Before we conclude this session, I have 2 announcements." She unfurled an official document bearing the court's seal. "First, by unanimous vote of the Judicial Council, the small Claims Division of this courthouse will henceforth be known as the Raymond Mercer Division of Community Justice, in recognition of Judge Mercer's lifelong commitment to access to justice for all citizens." Applause erupted again. Raymond looked genuinely surprised and moved by this announcement. "Second," Judge Harmon continued when the room quieted, "effective immediately, our rules regarding non-attorney advocates in small claims proceedings have been revised. Qualified individuals may now register to assist those who cannot afford or obtain legal representation under a new program that Judge Mercer has graciously agreed to oversee and develop. She turned to face the young attorneys who had participated in the mockery. And finally, those attorneys identified as having participated in the unfortunate social media incident will be required to complete 100 hours of pro bono service in the Small Claims Division under Judge Mercer's supervision as a condition of maintaining good standing with the bar. Daniel Harper felt dozens of eyes turn toward him. His career aspirations flashed before his eyes, making partner, prestigious clients, financial security, all potentially derailed by his own thoughtless cruelty. And yet, beneath the humiliation and fear, a small voice whispered that perhaps this consequence was not punishment, but opportunity. A chance to learn from a legal legend what no law school could teach. As the formal session concluded and people began to file out, many stopping to shake Raymond's hand or request a moment of his time, Daniel remained frozen in his seat. How could he face this man he had so callously mocked? What could he possibly say? He was still sitting there, long after most had left, when a shadow fell across him. Looking up, he saw Raymond Mercer standing before him, judicial robes now removed, looking once again like the humble advocate Daniel had ridiculed. "Mr. Harper," Raymond said quietly, "I believe we have some work to do together." Daniel stood on shaky legs, unable to meet the older man's eyes. "Judge Mercer, there's nothing I can say that would—" "Perhaps not," Raymond interrupted, gently. "But there is much you can do. Mrs. Santiago needs help with her landlord dispute. Shall we begin there?" In that moment, faced with Raymond's quiet dignity and offered redemption, Daniel Harper experienced something he hadn't felt since his first year of law school. The humbling recognition of how much he had yet to learn, not just about law, but about justice, compassion, and what it truly meant to be a member of the legal profession. "Yes, sir," he managed, his voice barely above a whisper. "I'd be honored." As they walked together toward the Small Claims Division, soon to be renamed in Raymond's honor, the elder jurist placed a hand briefly on the young attorney's shoulder. "The law is a jealous mistress, Mr. Harper, but she rewards those who serve her with integrity and humility. Remember that, and you may yet become the lawyer you imagined being when you first applied to law school." For the first time in years, Daniel Harper felt the idealism that had led him to law school stirring again, awakened by the gentle wisdom of a man he had dismissed as irrelevant just days before. The impact of that day resonated deeply through the county courthouse. Daniel Harper and the other attorneys who had participated in the mockery found themselves immersed in the newly christened Raymond Mercer Division of Community Justice, working alongside the very man they had once ridiculed. The experience proved transformative in ways none of them had anticipated. Daniel's first case under Judge Mercer's supervision involved Mrs. Santiago, a 68-year-old Puerto Rican immigrant facing eviction from her apartment of 23 years. The landlord, a large property management company, claimed lease violations, specifically unauthorized modifications to the apartment. In reality, Mrs. Santiago had simply installed grab bars in her bathroom after a fall, a reasonable accommodation for her disability. "What's our strategy?" Daniel asked as they reviewed the case in Judge Mercer's modest office, formerly a storage room that had been hastily converted to accommodate his new role. Raymond looked at him thoughtfully. "What do you think it should be, Mr. Harper?" Daniel fell back on his corporate training. "Well, we could file for an emergency injunction citing the Fair Housing Act, threaten a discrimination countersuit, maybe bring in the Department of Housing and Urban Development." "All excellent legal maneuvers," Raymond nodded. "But I asked what our strategy should be, not what weapons we should deploy. What's your assessment of Mrs. Santiago?" Daniel hesitated. He'd spent exactly 12 minutes with the elderly woman, most of it collecting basic information. "She's vulnerable," Scared. Doesn't speak English very well. And the property manager you'll be facing? Jason Keller. I've opposed him before in housing court. Aggressive, technically competent, but not brilliant. Hates to lose. Raymond smiled slightly. So our elderly client fears becoming homeless, while our opponent fears a bruised ego. Remember that distinction, Mr. Harper. It informs everything that follows. Over the next 3 days, Daniel watched in fascination as Raymond approached the case with a methodology unlike anything taught in law school. They visited Mrs. Santiago's apartment, documenting not just the grab bars, but the immaculate condition of the unit, the family photos covering the walls, the carefully tended plants on the small balcony. They spoke with neighbors who attested to her character. They researched the property company's history of similar actions against aging tenants, a pattern emerging of using technical violations to remove long-term residents paying below market rates. Most surprisingly to Daniel, Raymond insisted they visit the property management office directly, requesting a meeting with Keller rather than serving papers. "Won't this just give him time to prepare?" Daniel objected. "We're not trying to ambush him, Mr. Harper. We're trying to solve a problem." The meeting was tense but productive. Raymond spoke to Keller with unfailing courtesy while methodically laying out the facts: the documented disability, the reasonable accommodation standard under federal law, the pattern of similar actions against elderly tenants, and finally, most effectively, the human cost to Mrs. Santiago. "Mr. Keller," Raymond said quietly as their meeting concluded, "before you proceed, I invite you to imagine explaining to a judge, or perhaps to your own mother, why a woman who has paid her rent faithfully for 23 years should become homeless because she didn't want to fall in her shower." Keller, who had begun the meeting with aggressive confidence, now shifted uncomfortably. "The company has policies." "Indeed," Raymond nodded, "and the law has protections. We will vigorously pursue every one of them if necessary. But I suspect neither of us wishes to spend the next 6 months in litigation when a simple accommodation letter in Mrs. Santiago's file would resolve this matter today." 3 hours later, Daniel watched in amazement as Keller signed an agreement, not only permitting the bathroom modifications, but also extending Mrs. Santiago's lease for 5 years at her current rent. No court appearance, no contentious legal battle, just a solution that served justice without unnecessary conflict. "How did you know he would agree?" Daniel asked as they left the management office. "I didn't," Raymond replied simply, "but I knew that beneath the adversarial posturing that our profession sometimes encourages, most people prefer to do the right thing when given the opportunity, and when the alternatives are made clear." He paused, looking at Daniel directly. "Remember, Mr. Harper, we're not just lawyers, we're problem solvers. Sometimes the most effective advocacy happens outside the courtroom." Over the following weeks, Daniel's education continued. Each case brought new lessons, not just in legal strategy, but in human understanding. Raymond never lectured or condescended. Instead, he guided through example, through thoughtful questions, through gentle correction when necessary. On their 4th case together, Daniel arrived at the courthouse to find Raymond already meeting with their client, Mr. Gaines, an elderly veteran facing a predatory loan foreclosure on his mobile home. "Tell me about your service, if you don't mind my asking," Raymond was saying as Daniel entered. Mr. Gaines, a thin man with deeply lined features, straightened slightly. 25th Infantry Division, Vietnam, 2 tours. Raymond nodded. "Tropic Lightning, Honorable Division." Mr. Gaines studied Raymond with new interest. "You serve?" "JAG Corps, initially. Later Civilian Legal Counsel to the Department of Defense. Different kind of service than yours, but it gave me appreciation for what men like you endured." A connection formed between the two elderly men, transcending the lawyer-client relationship. Daniel watched, realizing he would have launched straight into paperwork and legal options, missing this crucial human dimension entirely. When Mr. Gaines stepped out to use the restroom, Daniel asked quietly, "Is that relevant to the case? His military service?" "Everything about a client is relevant, Mr. Harper, not just for potential legal arguments or sympathetic narratives, but for understanding who they are and what justice means to them personally." Raymond gathered his notes methodically. Mr. Gaines doesn't merely need legal representation. He needs to maintain his dignity throughout this process. For a man who served his country honorably, that matters deeply. The lesson proved prescient. When they appeared before Judge Sandoval the following day, the opposing counsel, representing the finance company, attempted to portray Mr. Gaines as financially irresponsible, a poor risk who had missed payments through negligence. Without prompting from Raymond, Daniel found himself rising in objection. "Your Honor, before opposing counsel continues mischaracterizing my client, I believe it's relevant to note that Mr. Gaines's payment issues began precisely when the VA temporarily suspended his disability benefits due to an administrative error on their part, an error they have since acknowledged in writing." He gestured respectfully toward Mr. Gaines. "My client served 2 tours in Vietnam with the 25th Infantry. He's been a homeowner for 40 years with no prior financial issues. This is not a case of irresponsibility, but of a dedicated veteran caught in circumstances beyond his control." Judge Sandoval's expression softened visibly. The opposing counsel, sensing the shift in the courtroom atmosphere, quickly adjusted his approach. By the end of the hearing, a payment plan had been approved that would allow Mr. Gaines to keep his home. As they were gathering their materials to leave, Raymond placed a hand briefly on Daniel's shoulder. "Well done." Those 2 simple words of approval from a man he had once mocked meant more to Daniel than any commendation he'd received in his professional career. The transformation wasn't limited to Daniel Harper. The other attorneys assigned to pro bono service under Raymond's supervision experienced similar evolutions. Melissa Chen, who had initially viewed her service as a punishment to be endured, now voluntarily extended her hours in the Community Justice Division. Thomas Whitaker, a third-year associate known for his ruthless approach to corporate litigation, developed a specialty in helping seniors navigate Medicare appeals, finding unexpected satisfaction in tangible results that improved people's lives directly. Word spread throughout the legal community. Attorneys, not subject to the mandatory service, began volunteering their time. Law students from the State University requested internships specifically in the Raymond Mercer division. What had begun as a disciplinary measure was evolving into a model program, attracting attention from neighboring counties and even the State Bar Association. 6 weeks into the program, the division held its first formal staff meeting. Raymond had insisted on a round table rather than a hierarchical arrangement, with everyone, from the most senior volunteer attorneys to the administrative assistants, seated as equals. "Before we begin," Raymond said, looking around the table, "I want to acknowledge the remarkable work being done by everyone in this room. In just over a month, this division has assisted 78 clients, prevented 12 evictions, secured benefits for 17 veterans, and helped 9 elderly citizens avoid foreclosure." He paused, his gaze moving from face to face. These numbers represent not just legal victories, but human lives stabilized, dignity preserved, justice made accessible. You should all be proud. Daniel glanced around the table, noting how different this felt from the corporate law firm meetings he was accustomed to, where billable hours and client acquisition dominated the discussion. Here the focus remained firmly on the people served. "Now," Raymond continued, "I'd like each of you to share one insight you've gained from your work here, something that might benefit your colleagues." The sharing began hesitantly but soon flowed freely. Thomas Whitaker described a technique for simplifying complex medical terminology when helping seniors with healthcare appeals. Melissa Chen offered observations on effective communication with clients who speak English as a second language. Even the division's receptionist, Mrs. Gladwell, contributed valuable perspectives on making anxious clients feel welcome. When Daniel's turn came, he found himself speaking from the heart. I've learned that what we call small claims are never small to the people involved. What seems like a minor legal matter to us can be life-altering for our clients. That perspective has changed how I approach every case. Raymond nodded approvingly. Well said, Mr. Harper. He turned to address the entire group. This division bears my name, but its true identity is being shaped by each of you. The work we do here may never make headlines or set precedents cited in law schools, but it fulfills the most fundamental promise of our legal system, that justice is not a luxury good available only to those who can afford it. After the meeting concluded, Daniel lingered, helping Raymond organize materials for the following day's cases. Something had been weighing on his mind, and he finally found the courage to address it directly. Judge Mercer, he began, setting down a stack of files. I've never properly apologized for what I did. The video, the comments, it was inexcusable. Raymond looked up from his notes. Yes, it was. The blunt agreement caught Daniel off guard. He had expected gracious dismissal of his actions, not frank acknowledgement of their impropriety. However, Raymond continued, apologies are measured not by words, but by changed behavior. In that regard, Mr. Harper, you have been apologizing most eloquently through your work these past weeks. He removed his reading glasses, fixing Daniel with a direct gaze. When I was a young attorney, long before my appointment to the federal bench, I made a similarly regrettable error. I dismissed an elderly legal aid lawyer as outdated and ineffective, only to later discover he had argued 3 cases before the Supreme Court and written portions of the Civil Rights Act. Daniel's eyes widened in surprise. What did you do? Much as you're doing now, I learned from him. I allowed myself to be humbled. That experience fundamentally changed my approach to both law and people. Raymond smiled slightly. Humility is an uncomfortable but excellent teacher. Their conversation was interrupted by Mrs. Gladwell, the division's receptionist. Judge Mercer, there's a walk-in client who's quite distressed. Foreclosure situation seems urgent. Send them in. Please, Raymond replied, rising to his feet. The woman who entered appeared to be in her early 60s, clutching a stack of legal notices with trembling hands. Her eyes were red from crying, but she carried herself with determined dignity. I'm sorry to come without an appointment, she began, voice quavering. The bank says they're selling my house next week. I've owned it for 30 years, but after my husband died and medical bills piled up. She trailed off, fighting for composure. Daniel expected Raymond to take the lead, but instead the elder jurist turned to him. Mr. Harper, would you assist Mrs. Delaney? The woman supplied. Margaret Delaney. Would you assist Mrs. Delaney with her situation? Raymond asked, his expression conveying confidence in Daniel's ability. Of course, Daniel replied, gesturing to a chair. Mrs. Delaney, please sit down. Let's go through these notices together and figure out our options. As Daniel began reviewing the documents with the distressed homeowner, he felt Raymond watching. Approvingly, he approached the case with newfound patience and empathy, explaining complex legal concepts in accessible language, outlining possible strategies without overwhelming her, and, most importantly, treating her with the respect and dignity her situation deserved. By the end of their impromptu consultation, Mrs. Delaney's panic had visibly subsided. They had a clear plan, an emergency motion to stay the foreclosure, negotiations with the bank for loan modification, and exploration of several assistance, programs for which she likely qualified. Mr. Harper will be your attorney throughout this process, Raymond explained as they concluded the meeting. "He's one of our finest advocates." The trust implicit in those words, coming from a man Daniel had once ridiculed, filled him with both pride and a deep sense of responsibility. After Mrs. Delaney left, visibly calmer than when she had arrived, Raymond turned to Daniel. "You handled that beautifully." "I had an excellent teacher," Daniel replied sincerely. Raymond shook his head slightly. "The capacity was always within you, Mr. Harper. You simply needed to reconnect with the reason you became an attorney in the first place." He paused, studying the younger man. "Why did you choose law as your profession? Not the answer you gave in interviews, but the real reason." Daniel considered the question honestly. "My grandfather lost his business to a fraudulent contract. No one would help because he couldn't afford the legal fees. I thought I could be the kind of lawyer who prevented that from happening to others." He laughed softly, the sound tinged with irony. "Somewhere along the way, I became exactly the kind of lawyer I once resented. Until now," Raymond observed quietly. "Until now," Daniel agreed. The following morning, Daniel arrived at the courthouse early, intending to prepare for Mrs. Delaney's emergency hearing. To his surprise, he found a group of attorneys from his firm's litigation department waiting in the lobby, including Victoria Slater, the managing partner. "Victoria," he greeted her cautiously, "what brings you here?" "You do, actually," she replied, her expression unreadable. "I've been hearing interesting reports about your work in this division. The partners and I thought we should see for ourselves what has apparently captivated one of our most promising associates." Daniel felt a flicker of anxiety. Was this professional intervention? Had his dedication to pro bono work raised concerns about his commitment to the firm? "We have a busy calendar today," he said carefully. "Judge Mercer has established quite an efficient operation." "So, I've heard," Victoria replied. "That's why we're here. We'd like to observe, if that's permitted." Before Daniel could respond, Raymond appeared, greeting the assembled attorneys with his customary quiet courtesy. "Miss Slater, I believe we met at the State Bar Conference last year. Welcome to our division. You and your colleagues are certainly welcome to observe our proceedings, provided our clients consent." Victoria seemed slightly taken aback by being recognized. "Thank you, Judge Mercer. We appreciate the opportunity." As the day progressed, Daniel felt increasingly self-conscious under the watchful eyes of his firm's leadership. They observed as he argued Mrs. Delaney's emergency motion, securing a 30-day stay of foreclosure. They watched his patient interaction with an elderly couple being sued by an aggressive debt collector over a medical bill they had already paid. They witnessed his methodical dismantling of a predatory contract that had entrapped a non-English-speaking immigrant family. Throughout it all, Raymond provided guidance when needed, but increasingly allowed Daniel to take the lead, displaying evident confidence in his abilities. During the lunch recess, Victoria approached Daniel in the hallway. "This is not what I expected," she admitted. "What did you expect?" Daniel asked. "Frankly, glorified paperwork, basic legal aid. Instead, I'm seeing sophisticated advocacy addressing complex issues." She glanced toward Raymond, who was conferring quietly with a client across the corridor. "And I'm seeing a different Daniel Harper than the one who works at our firm. More engaged, more authentic." Daniel considered her observation. "It feels different," he acknowledged. "At the firm, I'm constantly aware of billable hours, client development, partnership track considerations. Here, I'm just focused on solving problems and helping people who genuinely need it." Victoria studied him thoughtfully. "The firm is considering establishing a dedicated pro bono division, a real one, not just the token program we currently have to satisfy bar requirements. Your experience here could be valuable in shaping that initiative. Daniel's surprise must have shown on his face, because Victoria continued with unusual candor. That social media incident was deeply embarrassing for the firm, but how we respond to it matters. Perhaps this is an opportunity to transform a mistake into something meaningful. As she walked away, Daniel felt a complex mixture of emotions. The prospect of bringing what he'd learned under Raymond's tutelage to a broader platform was exciting, yet there was something special about the Raymond Mercer division. A purity of purpose, an absence of corporate politics, a direct connection between legal work and human impact. That afternoon, as the final case concluded and the visiting attorneys departed, Raymond invited Daniel into his office. "Your colleagues seemed impressed," he observed, arranging files with his characteristic precision. "They're talking about starting a pro bono division at the firm," Daniel replied. "They want me involved in developing it." Raymond nodded, seeming unsurprised. "And how do you feel about that possibility?" Daniel hesitated, conflicted. "Part of me sees the potential to expand what we're doing here, to help more people. Another part worries about corporate priorities, eventually compromising the mission. A legitimate concern," Raymond acknowledged. "But consider this. What if the lessons you've learned here about dignity, about justice as service rather than product, about seeing the human being behind every legal issue, what if those lessons could influence not just your practice but an entire firm's approach?" He gazed out the small window of his office, where the late afternoon sun cast long shadows across the courthouse plaza. "Transformation rarely happens all at once, Mr. Harper. More often it spreads gradually, person to person, practice to practice." He turned back to Daniel. "The question is not whether your firm will change you back, but whether you have changed enough to help transform your firm." Bim! As Daniel contemplated those words, a court clerk appeared at the door. "Judge Mercer, there's someone here to see you. Says it's important." Raymond's visitor proved to be Jason Keller, the property manager they had negotiated with on Mrs. Santiago's case. He entered Raymond's office with visible discomfort, his usual confident demeanor replaced by uncharacteristic hesitation. "Judge Mercer, Mr. Harper," he acknowledged with a nod. "I apologize for the unscheduled interruption." "Duh. No interruption at all," Raymond replied, gesturing to a chair. "How can we help you?" Keller remained standing, hands clasped behind his back. "Actually, I came to offer help, not request it." He took a deep breath. "After our interaction regarding Mrs. Santiago, I've been reflecting. The company I represent owns 17 properties in this county, primarily in lower-income neighborhoods. We have over 200 elderly tenants similar to Mrs. Santiago." He paused, seeming to gather his thoughts. "I've spoken with my regional director about implementing a company-wide policy regarding reasonable accommodations for aging residents. We'd like your input on developing guidelines that would prevent situations like Mrs. Santiago's from arising in the first place." Daniel exchanged a surprised glance with Raymond, who showed no astonishment at all, only thoughtful consideration. "That would be a significant positive step, Mr. Keller," Raymond said. "I'd be happy to review any draft policies your company develops." "Actually," Keller continued, "we were hoping for more than review. We'd like to work collaboratively with your division to develop a comprehensive approach, one that protects both our legitimate business interests and our residents' dignity and rights." The request hung in the air for a moment. Daniel found himself wondering about Keller's motivation. Was this genuine concern, or merely a corporate attempt to avoid future legal confrontations? Raymond seemed to read his thoughts. "What prompted this initiative, if you don't mind my asking?" Keller's professional facade cracked slightly. "My mother," he admitted. "She's 76, recently widowed. After our meeting about Mrs. Santiago, I visited Mom's apartment and realized—" He shook his head. "Let's just say I saw her. Placed through new eyes. She had installed similar grab bars without telling the management company. Under our current policies, she could face the same situation." The personal revelation transformed Daniel's perception of the property manager. No longer just a corporate adversary, Keller became a person navigating the complex intersection of professional responsibility and personal values, not unlike Daniel himself. "I believe we can help," Raymond said warmly. "Perhaps you could join us for lunch next week to discuss parameters?" After Keller departed, promise of collaboration in hand, Daniel turned to Raymond with newfound appreciation. "You expected this, didn't you? That's why you insisted we meet with him directly rather than serving papers." Raymond smiled slightly. "I hoped for it. Most people want to do the right thing, Mr. Harper. Sometimes they just need someone to illuminate the path." The encounter with Keller marked a turning point in the Raymond Mercer division's approach. Rather than simply addressing individual cases as they arose, they began developing preventative initiatives, reaching out to companies, agencies, and organizations frequently involved in disputes with vulnerable populations. By the 3-month mark, the division had established collaborative programs with 2 property management companies, a local hospital regarding medical debt collection practices, and the county's largest payday lending chain. Each program aimed to address systemic issues before they resulted in legal crises for individuals. The morning of the division's quarterly review dawned clear and crisp. Daniel arrived early, as had become his habit, to find Judge Harmon waiting outside Raymond's office. "Mr. Harper," she greeted him, "a moment of your time?" They stepped into an empty conference room, where Judge Harmon closed the door before speaking. "I wanted to speak with you privately before the formal review. How would you assess Judge Mercer's health and stamina?" The question caught Daniel off guard. He's been consistently present and engaged. His mind is sharper than most attorneys half his age. "Why do you ask?" Judge Harmon sighed. "I've noticed him tiring more easily these past weeks. Yesterday, he requested a short recess during afternoon proceedings, something he's never done before." Concern flickered through Daniel. He had been so focused on his own transformation and the division's work that he hadn't fully registered the physical toll the program might be taking on its elderly namesake. "He's 72, Judge Harmon continued, "and while his intellectual capacity remains extraordinary, this division has grown far beyond what anyone anticipated. What began as a small corrective program now handles hundreds of cases, the administrative burden alone." "Has he said anything?" Daniel asked. "He wouldn't," Judge Harmon replied with a sad smile. "That's not his way. He'd work himself to exhaustion before admitting limitations." Before Daniel could respond, they were interrupted by the arrival of court administrators and representatives from the State Bar Association, gathering for the quarterly review. Daniel pushed his concern to the back of his mind, but found himself observing Raymond more closely throughout the meeting. The review proceeded smoothly. The statistics were impressive. Over 300 cases handled, an 87% favorable resolution rate, innovative preventative programs established, and a substantial reduction in repeat legal issues among served populations. Representatives from 3 neighboring counties expressed interest in replicating the model. Raymond presided over the presentation with his usual quiet authority, deflecting personal praise and highlighting the contributions of others. But Daniel noticed what Judge Harmon had referenced, moments when Raymond's energy seemed to flag, when he leaned more heavily on his cane, when his voice, though still commanding, required more visible effort. As the meeting concluded and attendees filed out with congratulations and commendations, Daniel remained behind. Raymond was gathering his notes with methodical care, his movements deliberate. "A successful review," Daniel observed. "The program's impact is undeniable." "Indeed," Raymond agreed, "though we must be careful not to become enamored with statistics. Behind each percentage point are human lives." "Judge Mercer," Daniel began carefully, "would you join me for dinner this evening? There's a matter I'd like to discuss away from the courthouse." Raymond studied him with those perceptive eyes that seemed to read intentions as clearly as legal briefs. "Of course, Mr. Harper, though I suspect I know the subject you wish to address." That evening they met at Claudia's, a small Italian restaurant known for its quiet atmosphere and excellent minestrone. After they had ordered and the waiter had departed, Daniel broached the subject directly. "Judge Harmon is concerned about your workload. So am I." Raymond nodded, unsurprised. Eleanor always was observant. It was what made her an excellent law student and makes her an exceptional judge. "The division has grown exponentially," Daniel continued. "What started as a limited program has become a full-fledged operation handling hundreds of cases. The administrative demands alone are more taxing than I anticipated," Raymond acknowledged, his honesty disarming Daniel's prepared arguments. "The body has its limitations, however much the spirit might resist them." He sipped his water, thoughtfully, "But the work is too important to scale back. Too many people depend on these services now." "No one is suggesting scaling back," Daniel assured him, "but perhaps restructuring the leadership, distributing the administrative burden while maintaining your guidance on legal strategy and mentorship." Raymond considered this. "What did you have in mind?" Daniel outlined a proposal he had been formulating since his conversation with Judge Harmon. The division would establish a rotating administrative director position, filled by experienced attorneys who would handle the operational aspects. Raymond would transition to a role focusing exclusively on case strategy, attorney mentorship, and program development, leveraging his wisdom without exhausting his energy. "A sensible approach," Raymond conceded after Daniel finished. "Though, I confess, a certain pride makes it difficult to acknowledge diminishing stamina." "It's not about stamina," Daniel countered gently. "It's about highest and best use of your extraordinary abilities. The division needs your legal mind and mentorship more than it needs you managing scheduling conflicts and budget spreadsheets." Raymond smiled, a genuine expression that softened the dignified lines of his face. "When I first encountered you in Judge Harmon's courtroom, Mr. Harper, I would not have anticipated receiving such thoughtful counsel from you mere months later. People can indeed surprise us, especially when we've misjudged them based on superficial impressions." "I had an excellent teacher in that regard," Daniel replied sincerely. Their conversation shifted to implementation details, and by the time they finished their tiramisu, a transition plan had taken shape. They would present it to Judge Harmon the following day, with the goal of implementing changes before Raymond reached a breaking point. As they were preparing to leave, Raymond paused, his expression growing more serious. "There's another matter I've been meaning to discuss with you, Mr. Harper. Of course, your 100 hours of mandated service concluded 2 weeks ago. Yet you've continued to devote substantial time to the division, time that I imagine your law firm values highly." Daniel hadn't realized he'd completed his required hours. The division's work had ceased to feel like an obligation and had become, instead, a calling, a reconnection with his original purpose in becoming an attorney. Victoria Slater mentioned the firm's interest in establishing a formal pro bono division, Daniel said. "I've been gathering practical experience to help shape that initiative." "A commendable goal," Raymond acknowledged, "but I wonder if it fully captures your path forward." "What do you mean?" Raymond considered his words carefully. I've observed many young attorneys throughout my career, Mr. Harper. Those with your level of talent generally follow one of two trajectories. Most pursue the traditional markers of success: partnership at prestigious firms, wealth accumulation, professional status. A smaller number discover that their definition of success lies elsewhere, in work that nourishes the soul while still challenging the intellect. He leaned forward slightly. You exhibit a natural gift for this type of advocacy, seeing beyond legal technicalities to the human dimensions of each case. That's rarer than you might think, and infinitely valuable. Daniel felt oddly vulnerable under Raymond's perceptive gaze. Are you suggesting I leave corporate law entirely? I'm suggesting you consider all paths available to you, not just those most frequently traveled or externally validated. Raymond's tone was gentle but direct. The question is not what kind of lawyer others expect you to be, but what kind of lawyer brings you genuine fulfillment. The conversation lingered in Daniel's mind as he drove home that evening. He had entered law school with idealistic notions about justice and helping others, only to have those ideals gradually subsumed by student loan pressures, peer competition, and the allure of prestigious firm offers. The mocking video he had posted, behavior that now made him cringe with shame, represented the culmination of that drift from his original values. These past months in the Raymond Mercer division had reconnected him with something he had lost. Each day brought challenges as intellectually demanding as any corporate case, but with immediate, tangible human impact. The gratitude in Mrs. Santiago's eyes when she learned she could stay in her home. The relief on Mr. Gaines's face when his foreclosure was halted. Mrs. Delaney's tears when they secured a loan modification that reduced her payments by 30%. These moments provided a form of professional satisfaction entirely different from winning a motion or closing a lucrative deal. Yet Daniel was pragmatic enough to recognize the practical considerations. His student loans were substantial. The lifestyle differences between corporate and public interest law were significant, and there was the matter of his professional identity, how he saw himself and how others perceived him. The following morning, Daniel arrived at the courthouse to find an unusual scene unfolding. A television news crew was setting up in the lobby, and a cluster of well-dressed officials stood conversing near the entrance to the Raymond Mercer division. "What's happening?" he asked a court clerk hurrying past with an armful of files. "State Attorney General is here," she replied without slowing. "Apparently we're about to become famous." Daniel made his way through the growing crowd to find Raymond and Judge Harmon, speaking with a distinguished woman he recognized as Attorney General Sophia Vega. Mr. Harper," Raymond greeted him. "Perfect timing. Attorney General Vega was just asking about the division's day-to-day operations. You're better positioned than I to address those details." For the next 20 minutes, Daniel found himself explaining the division's workflow, case selection criteria, and preventative initiatives to the state's highest-ranking legal officer. To his surprise, she listened with genuine interest, asking insightful questions that revealed a deep understanding of access to justice issues. "This program addresses a critical gap in our legal system," she commented as Daniel concluded. "A gap I've been concerned about since taking office." She turned to Raymond. "Judge Mercer, I came here today not just to observe, but to make a proposal. The state is establishing a new Office of Community Justice designed to replicate successful models like yours throughout all 87 counties. We need someone with both the legal expertise and the moral authority to lead this effort." She smiled warmly. "I can think of no one better qualified than yourself." Raymond appeared momentarily taken aback, a rare break in his usual composed demeanor. "I'm deeply honored, Madam Attorney General. However, at my age, taking on a statewide initiative of that scope would be—" "We anticipate a 3-person leadership team," she continued. You as chief legal strategist, focusing on program design and attorney training. The administrative and operational aspects would be handled by co-directors with complementary expertise. She glanced at Daniel. In fact, we were hoping Mr. Harper might consider serving as one of those co-directors based on Judge Harmon's strong recommendation. Now it was Daniel's turn to be speechless. Judge Harmon had recommended him for a state-level leadership position, the same judge who had witnessed his most shameful professional behavior just months earlier. This is unexpected, he managed finally. The best opportunities often are, Attorney General Vega replied. I don't need an answer immediately from either of you. Review the proposal details, discuss it together, but I hope you'll both consider it seriously. The program you've built here deserves to be replicated statewide. After she departed, accompanied by her entourage and the media contingent, Daniel turned to Judge Harmon in disbelief. You recommended me, after everything that happened? Judge Harmon's expression was both stern and kind, the same complex blend he had come to associate with Raymond's mentorship. I recommended the attorney I've observed these past months, Mr. Harper, not the one who posted that video. She straightened a stack of files with judicial precision. People make mistakes, especially young attorneys caught up in firm culture and peer pressure. What matters is how they respond when confronted with those mistakes. Some become defensive. Others offer hollow apologies while changing nothing. A very few, undergo genuine transformation. She met his gaze directly. You're not the same lawyer who walked into my courtroom mocking an elderly advocate. That young man wouldn't have recognized the value in what you're doing now, let alone found fulfillment in it. Later that afternoon, Daniel found Raymond in the courthouse garden, seated on a bench beneath a flowering dogwood. The elder jurist appeared to be meditating, eyes closed, face tilted toward the dappled sunlight filtering through the branches. Judge Mercer, am I interrupting? Raymond opened his eyes, smiling slightly. Not at all. Just giving these old bones a moment's rest while contemplating unexpected paths. Daniel settled beside him on the bench. The Attorney General's proposal? Indeed. When I agreed to oversee this division, I envisioned a modest program, a few attorneys completing their mandated service, perhaps some minor systemic improvements. I never imagined state-level replication. Will you accept the position? Daniel asked. Raymond turned to study him. That depends in part on you, Mr. Harper. This type of initiative requires partners who share both vision and values. The question is whether you're prepared to diverge from the conventional career path you've been following. Daniel had spent the morning wrestling with precisely that question. The Attorney General's offer would mean leaving Brookfield and Stern, abandoning the partnership track he had worked toward for years. It would mean a government salary rather than corporate compensation. It would mean defining success by metrics entirely different from those his law school classmates would recognize. Yet it would also mean purpose, impact, work aligned with his deepest values rather than external expectations. I've been thinking about something you said when we first started working together, Daniel said slowly, about how the most effective advocacy often happens outside the courtroom. I think the same might be true about the most meaningful legal careers. They might happen outside the traditional paths we're conditioned to pursue. A slight smile crossed Raymond's face. Does that mean you're considering the offer? More than considering, Daniel admitted. But I have practical concerns. Student loans primarily. The Public Service Loan Forgiveness Program would apply to this position, Raymond pointed out. And while the salary would be less than your firm pays, the state offers stability and benefits that have their own value. He paused, studying Daniel thoughtfully. But there's another consideration beyond the practical. This type of career requires certainty about one's purpose. The external validation that comes with firm prestige and high compensation won't be there to sustain you during difficult periods. You need to be certain that the work itself provides sufficient reward. Daniel reflected on the past 3 months. The challenges, the learning curve, the profound satisfaction of helping vulnerable clients navigate a system designed to overwhelm them. He thought about Mrs. Santiago, safe in her home of 23 years. About Mr. Gaines, his dignity preserved along with his residence. About Mrs. Delaney, whose gratitude had manifested in a loaf of homemade banana bread delivered to the division office weekly since they had saved her home. "I'm certain," he said finally, surprised by his own clarity, "more certain than I've been about any professional decision since choosing law school." Raymond nodded, seeming satisfied. "Then I believe we have the beginning of a partnership, Mr. Harper, one that might help transform access to justice across our state." As they sat in companionable silence, watching clouds drift across the autumn sky, Daniel reflected on the extraordinary path that had led him to this moment. How a thoughtless act of mockery had set in motion a sequence of events that led to profound personal and professional transformation. How meeting Raymond Mercer, first as an object of derision, then as a mentor, had reconnected him with his original purpose in becoming an attorney. "You know," Raymond said thoughtfully, breaking the silence, "when that young clerk laughed at me in Judge Harmon's courtroom, I felt a momentary sting, not because I needed recognition, but because I recognized in him what I once was, talented, but untethered from the deeper purpose of our profession. I saw potential being wasted on posturing and pursuit of status." He turned to Daniel with a gentle smile. "I never anticipated that the same young man would become not just a colleague, but a partner in expanding the work I care most deeply about. Life does take unexpected turns." "They laughed when you entered the courtroom," Daniel said quietly, "until the judge noticed your medal. But the real discovery wasn't your past accomplishments. It was what you were still capable of creating." Raymond nodded, his eyes reflecting wisdom earned through decades of service. "The medal recognized what I had done. This division, and now this statewide initiative, represents what we can yet do. And that, Mr. Harper, is the more meaningful legacy." As the afternoon sun cast long shadows across the courthouse garden, teacher and student, elder statesman and young advocate sat side by side, two legal minds separated by generations but united in purpose, planning a future where justice would be more accessible to all. In that moment, Daniel Harper understood with perfect clarity that true success wasn't measured in billable hours or corner offices, but in lives improved, dignity preserved, and justice made real for those who needed it most. The path ahead might not be the one he had once envisioned, but it was unquestionably the right one, not just for those they would serve, but for his own fulfillment as both attorney and human being. "Ready to change the world, Judge Mercer?" he asked with a smile. Raymond rose to his feet with the deliberate care of his 72 years, but his eyes held the undimmed fire of purpose that had defined his remarkable career. "One case at a time, Mr. Harper," he replied. "One case at a time." 2 years later, Daniel stood at the podium in the state capitol's grand hall, surveying the assembled crowd with a sense of pride and accomplishment that still occasionally felt surreal. Attorneys, judges, community advocates, and state officials filled the ornate room, gathered to celebrate the 2nd anniversary of the Office of Community Justice. At the front of the audience sat Raymond Mercer, now 74, his posture still erect with dignity despite the cane that now permanently accompanied him. "When we launched this initiative 2 years ago," Daniel began, his voice carrying confidently through the hall, Many doubted that a statewide program focused on accessible justice could succeed. Legal services for vulnerable populations have traditionally been underfunded, understaffed, and undervalued. He paused, making eye contact with various attendees. The Attorney General, Judge Harmon, Jason Keller, now director of his company's senior housing division, and finally Raymond, whose approving nod gave Daniel the same quiet confidence it had from the beginning. Today, I'm pleased to report that the Office of Community Justice has not merely succeeded, it has transformed how our state approaches legal services for its most vulnerable citizens. The statistics supported his claim. In 2 years, the program had expanded to all 87 counties, trained over 500 attorneys in community advocacy, prevented more than 3,000 evictions and foreclosures, secured benefits for thousands of veterans and seniors, and established preventative partnerships with dozens of companies and agencies to address systemic issues before they became legal crises. But numbers, as Raymond had taught him, never told the complete story. Behind these statistics are human lives, Daniel continued. Families who kept their homes, seniors who maintained their independence, veterans who received the benefits they earned through service, immigrants who found justice in a system often stacked against them. He gestured toward a wall where photographs were displayed, faces of clients whose lives had been changed through the program's intervention. Among them was Mrs. Santiago, now serving on her building's tenant council, Mr. Gaines, who had started a support group for veterans facing financial challenges, and Mrs. Delaney, who had transformed her saved home into a neighborhood resource center for other seniors navigating financial difficulties. These successes weren't achieved through traditional legal approaches alone, Daniel explained. They required a fundamental shift in how we view the attorney's role, not just as advocates within the system, but as architects of a more accessible and humane system. As he spoke, Daniel reflected on his own transformation. The corporate attorney who had mocked an elderly advocate now directed a statewide justice initiative, mentored young lawyers, and regularly testified before legislative committees on access to justice issues. His former firm colleagues had initially predicted he would return to corporate law within 6 months, unable to sustain the pay cut and prestige reduction. None had anticipated how deeply fulfilling he would find this alternative path. None of this would have been possible, Daniel continued, voice softening with genuine emotion, without the vision and guidance of one extraordinary individual. He turned toward Raymond. Judge Raymond Mercer didn't set out to create a revolution in legal services. He simply did what he had always done throughout his distinguished career. He saw a need for justice and filled it, without concern for recognition or reward. When a group of young attorneys, myself among them, mocked him for his humble approach, he responded not with righteous anger, but with the opportunity for education and growth. Raymond's expression remained composed, but his eyes reflected the depth of their shared journey. I stand before you today, not just as the co-director of the Office of Community Justice, but as living proof that transformation is possible, both for individuals and for systems. 2 years ago, I was a corporate attorney who had lost sight of why I became a lawyer. Today, thanks to Judge Mercer's example and mentorship, I've rediscovered that purpose and found fulfillment beyond anything I experienced in corporate practice. Daniel gestured to several young attorneys seated in the second row, the newest cohort of community justice fellows, recent law school graduates who had chosen public service over more lucrative options. The true measure of this program's success isn't just in the cases we've handled, but in the legal culture we're helping to reshape. These young attorneys represent a new generation committed to making justice accessible to all, not just those who can afford premium rates. As Daniel concluded his remarks and introduced the Attorney General, he caught Raymond's eye. The elder Jurist gave a slight nod, a gesture of approval that, even after 2 years of close collaboration, still filled Daniel with a sense of accomplishment no corporate commendation had ever matched. The formal ceremony transitioned to a reception, where Daniel found himself approached by a familiar face, Victoria Slater, his former managing partner at Brookfield and Stern. "Impressive results, Daniel," she greeted him, champagne flute in hand. "The firm has been following your progress." "Thank you, Victoria," he replied, genuinely pleased to see her. "How are things at Brookfield and Stern?" "Profitable as ever," she smiled, "though our pro bono division hasn't quite matched what you've built here. Perhaps that's why I've come." Victoria explained that the firm's partners had voted to establish a formal collaboration with the Office of Community Justice, committing 20 associates annually to 3-month rotations within the program, a substantial resource contribution that would significantly expand their capacity. "Your departure created quite the stir," Victoria admitted. "Several associates began questioning their own career paths. Rather than fight the tide, we decided to incorporate this type of service into our firm culture. Good for recruitment, good for retention, good for our public image. And good for the associates," Daniel added. "They'll become better lawyers." "So I've observed," Victoria agreed, her gaze traveling to where Raymond was engaged in conversation with a group of awestruck law students. "Your mentor is quite the legend now. Those students look at him the way first years look at Supreme Court justices." Daniel followed her gaze, noting the respectful attention the students gave to Raymond's every word. "With good reason. He's changed more lives through his retirement work than most attorneys do in their entire careers." After Victoria departed, with promises of formal partnership documents to follow, Daniel circulated through the reception, accepting congratulations and discussing program details with interested officials from other states considering similar initiatives. Throughout the evening, he remained aware of Raymond's location in the room, noticing his increasing fatigue as the hours progressed. When he saw Raymond discreetly check his watch for the 3rd time, Daniel smoothly intervened, citing a previously scheduled meeting that required both their attention. They made polite farewells and escaped to the quiet of Daniel's office down the hall. "Thank you," Raymond sighed, lowering himself carefully into a chair. "These events tax my stamina more than they once did." "You should have left after the speeches," Daniel admonished gently. "No one would have thought less of you." Raymond smiled. "Perhaps I'm not quite ready to fully embrace the limitations of age. There's still too much work to be done." That evening, as had become their tradition after significant program milestones, they had dinner at Claudia's, the same Italian restaurant where they had discussed restructuring the original courthouse division 2 years earlier. The owner now greeted them by name, leading them to their table in a quiet corner, where Raymond could rest his back against the wall and observe the restaurant without being disturbed. "To 2 remarkable years," Daniel proposed, raising his glass of mineral water in toast. Raymond had never been one for alcohol, preferring, as he put it, to keep the mind clear for whatever challenges might arise. "And to many more," Raymond returned, touching his glass to Daniel's. As they enjoyed their meal, Daniel found himself reflecting on how their relationship had evolved. What had begun as reluctant mentor and chastened student had developed into a genuine partnership based on mutual respect and shared purpose. Raymond still offered wisdom and guidance, but increasingly sought Daniel's perspective on program strategy and innovation. "I received an interesting letter yesterday," Raymond mentioned between bites of his risotto, "from Harvard Law School." Daniel raised an eyebrow. What did Cambridge want? "They're establishing a new center for community justice," Raymond explained. "Apparently our program has attracted academic attention. They've invited me to give the inaugural lecture and serve on their advisory board." That's excellent, Daniel enthused. A perfect platform to influence the next generation of attorneys. Raymond nodded, but his expression suggested more to the story. They've also expressed interest in having someone with practical program building experience join their faculty. A new clinical professorship focused on access to justice initiatives. Daniel paused, fork halfway to his mouth. They want you to teach. Not me, Raymond smiled. You. The offer caught Daniel completely by surprise. Me? A Harvard professor? Ah, clinical professor, Raymond clarified, teaching practical skills rather than theory, supervising students in actual community representation, building academic partnerships with programs like ours across the country. He studied Daniel's shocked expression with amusement. Is it so difficult to imagine? You've helped build a model program, co-authored 3 substantial articles on access to justice innovation, and testified before state and federal committees. You're precisely what they're looking for. Someone who bridges practical experience with intellectual rigor. Daniel struggled to process the possibility. Harvard Law, the pinnacle of legal academia, a platform to influence not just one state's approach to community justice, but potentially the national landscape through the attorneys who would graduate under his guidance. I hadn't considered an academic path, he admitted. Few practicing. Attorneys do, Raymond replied. But consider this, what we've built here is now structurally sound, with systems and personnel in place to sustain it. The question becomes, how do we ensure these principles spread beyond our state? How do we influence the broader legal culture? He leaned forward slightly. Teaching the next generation of attorneys is one powerful answer to that question. Daniel considered the possibility. I'd need to think about it, discuss it with Melissa. His relationship with Melissa Chen, who had undergone her own transformation from reluctant pro bono participant to passionate advocate, had deepened from professional colleagues to life partners over the past year. Daniel closed his hand around the pin, feeling its weight, not just of metal, but of legacy and responsibility. I will, I promise. Raymond nodded, satisfied. Then my mentorship has succeeded beyond my hopes, just as Judge Thurgood's did with me, and as yours will with the students yet to come. As they sat together in Daniel's office, mentor and protege, elder statesman and rising leader, the journey they had shared seemed to come full circle. From mockery to respect, from punishment to purpose, from individual transformation to systemic change, their story embodied the very principles they had worked to instill in the legal system itself. That true character reveals itself through actions, not appearances. That meaningful change begins with personal accountability. That justice, at its core, is about recognizing the dignity in every human being. They laughed when I entered the courtroom, Raymond reflected quietly, until the judge noticed my medal. But what matters isn't the recognition I received then. What matters is the work we've done since, the lives changed, the barriers removed, the dignity restored. He looked at Daniel with quiet pride. And now you'll carry that work forward, in ways I might never have imagined but can wholly celebrate. Daniel held the silver pin, this symbol of a legacy extending beyond any individual career, and made a silent vow to honor it, not just at Harvard, but in every aspect of his professional life. To remember always the elderly advocate who had transformed his understanding of what it meant to be not just a successful attorney, but a just one. Thank you, he said simply, words inadequate to express the depth of his gratitude. For everything. Raymond smiled, the expression lighting his dignified features with warmth. No, Daniel. Thank you for showing an old judge that his most meaningful contribution might come not from the bench, but from a chance to guide a promising young attorney back to his true purpose. As afternoon sunlight streamed through the office windows, mentor and protege sat in companionable silence, each contemplating the path that had brought them together and the legacy that would continue long after both had completed their professional journeys. A legacy not of prestigious titles or landmark cases, but of countless lives touched, dignity preserved, and justice made accessible to those who needed it most. In that moment, Daniel understood with perfect clarity that success wasn't measured by where you stood, but by who stood differently because of you. By that measure, Raymond Mercer was the most successful attorney he had ever known, and the standard toward which he would always strive. Up next, you've got two more standout stories right on your screen. If this one hit the mark, you won't want to pass these up. Just click and check them out. And don't forget to subscribe and turn on the notification bell so you don't miss any upload from us.